everyone. Welcome to the session of Legal Current Affairs for the month of July. I am Richa Kaur, Legal Faculty at Manu Law Classes. And today I'm going to be walking you through some important judgments that were pronounced by the Supreme Court during this period, as well as some important judgments passed by high courts in India. I should also outline some significant international developments that have taken place during this period. Now, before I begin, let me inform you that our organization has started the admissions process for its 1 year as well as 2 year courses for all the CLAT aspirants of the batch 2022-23. You can find out more about the same by going on our website lawentranceindia.com or by calling us on the number that you can see on the screen. We are also providing a free trial of 15 days. During this free trial, you would be granted access to live classes with one-to-one interaction. You would also be given recorded conceptual lectures on various topics, topic tests, sectional tests, as well as your performance would be analyzed. The process of signing up includes finding the link in the description below. You locate the sign up for 15 days free trial. Thereafter, you fill the form and you can get started. Now, let's start with the first judgment that was passed by the Supreme Court recently, which is Union of India versus Rajendra, Shah and others. In this case, the Supreme Court, it struck down 97th constitutional amendment to the extent that it related to cooperative societies. The court held that the amendment, it required ratification by 1/2 of the state legislatures as per Article 368, subclause 2 of the Constitution, since it dealt with an entry which is exclusively a state subject, that is cooperative societies. Now, since cooperative societies was a state subject, it required ratification by 1/2 of the state legislatures as mandated by the Constitution. And in the present case, since such ratification had not been obtained, therefore, the constitutional amendment was liable to be struck down. Next judgment is that of Prakash Gupta versus Securities and Exchange Board of India. In this case, the Supreme Court has held that the power of compounding or the power to compromise between the parties, it must be expressly conferred by the statute which creates the offense. Now, in respect of offenses which lie outside the Indian Penal Code, compounding may be permitted only if the statute that is creating the offense, it contains an express provision for compounding or for compromise. Before such an offense can be made compoundable. Now in India, only section 320 of CRPC, it provides for compounding of offenses which deal with IPC and not outside IPC. Therefore, this judgment is of significance as far as offenses outside the Indian Penal Code are concerned and power of compounding with respect to them. Now let's go to the next judgment, that is State of UP versus Manoj Kumar Sharma. Now in this case, a special leave petition had been filed by the UP government against the summoning order that was passed by the Allahabad High Court against certain public official in a contempt case. Now the Supreme Court, it held that judges, they cannot behave like emperors and they must not behave like emperors, and they should not call public officers to the court unnecessarily. The court reiterated that a practice has developed in certain high courts to call officers at the drop of a hat in order to exert direct or indirect pressure. Now, this line of separation of powers between the judiciary and the executive is sought to be crossed by summoning such officials in order to pressurize them to pass an order according to the whims and fancies of the court. Therefore, the court set aside the Allahabad High Court order whereby it had summoned certain public officials to the court. Now, next judgment is that of Raksh versus State of UP. Now, in this case, an appeal had been filed in the Supreme Court against the conviction order that was passed by the trial court and which was also upheld by the High Court. The court, it observed that for conviction of an accused, the recovery of the weapon that was used in the commission of the offense is not a sine qua non. That means for convicting the accused, recovery of the weapon that was used while committing that offense is not an essential ingredient to convict him. In this case, since both the witnesses to the incident, they had been thoroughly cross-examined, therefore minor contradictions that do not go to the root of the matter or that are not material contradictions, they cannot lead us to brush aside or disbelieve the evidence of these witnesses. The court further held that one is required to consider the entire evidence as a whole with the other evidence on record. Therefore, the Supreme Court in this judgment, it upheld the conviction order that was passed by the trial court and upheld by the High Court, and thereby dismissed the appeal. Next judgment is again that of the Supreme Court, which was called the KP Natarajan and another versus Muthalamal and others. In this case, the Supreme Court, it upheld the judgment of the Madras High Court, which had held that an ex parte decree that was passed against a minor, not represented by a guardian who is duly appointed, is a nullity. Now, in this case, the High Court, it was dealing with a revision petition that was filed under Section 115 of CPC against the refusal of the trial court to set aside the ex parte decree that was passed in a suit seeking specific injunction in or seeking specific performance of a sale agreement. Now, one of the defendants in the suit was a minor. Therefore, while considering the revision, the High Court had summoned records in order to ascertain if the guardian of the minor was duly appointed as per procedure. Now, the High Court, on finding that there was no proper appointment of the guardian, it set aside the ex parte decree as a nullity. The Supreme Court also held that failure to appoint a guardian ipso facto, it will result in prejudice to the minor and it need not be specially established. The Supreme Court, it also agreed with the High Court's view that decree as a whole is required to be set aside and not merely against the minor defendant. Moving on to the next judgment, that is in re-alarming newspaper report regarding Kavar Yatra in state of UP. In this case, the Supreme Court, it took suo motu cognizance of a report of Indian Express wherein it was stated that the state government of UP had allowed the Kavar Yatra to go on despite the COVID-19 pandemic. Now, by this judgment, the Supreme Court, it directed that the state of UP, it cannot go ahead with this decision to allow the Kavar Yatra amid the COVID-19 pandemic, since it concerns all citizens of India and is at the heart of the fundamental right to life. The court held that the health of citizenry of India and right to life is paramount. Therefore, all sentiments, whether they are religious sentiments, they are subservient to this basic fundamental right to life. Moving on to the next judgment, that is again of the Supreme Court, namely Madras Bar Association versus Union of India. Now, in this case, the Madras Bar Association, it challenged the validity of tribunal, appellate tribunal, and other authorities, qualifications, experience, and other conditions of service of members' rules 2020. The Supreme Court, it struck down these rules, which laid down minimum age limit of 50 years for appointment as a tribunal member. The court held that excluding young successful advocates by laying down a minimum age limit of 50 years for appointment as a tribunal member, it was arbitrary as well as discriminatory. Moving on to the next judgment, that is Indra Devi versus State of Rajasthan. In this case, the court has held that sanction under Section 197 of CRPC is required in order to prosecute public servants if the alleged act that is committed is directly concerned with official duty. Now, the court further observed that the yardstick that is to be followed is to form a prima facie view whether the act of omission for which the accused was charged had reasonable connection with the discharge of his duties. Now, in the present case, the role that was assigned to the respondent public servant was that he had conspired with his two superiors who had been granted protection under Section 197 of CRPC. Now, the court noted that there's no reason why a similar protection ought not to be granted to this respondent public servant, which was already granted to his two superiors by the High Court as well as the trial court, respectively. Therefore, the court allowed the appeal of the respondent public servant. Moving on to the next judgment. This is the judgment of the Jammu and Kashmir High Court, called as Arshad Ahmed Ali versus Union Territory of J&K and another. In this case, the Jammu and Kashmir High Court has held that when an accused is charged under both the provisions of NDPS Act as well as the Unlawful Activities Prevention Act, in such a circumstance, custody under NDPS Act may be extended beyond the expiry of 180 days that has been prescribed under the Unlawful Activities Prevention Act. Now, it also upheld the order of the Sessions Court, which had granted the extension and observed that such order of the Sessions Court was not passed without any jurisdiction, or it did not suffer from the vice of illegality or infirmity. The proviso to subsection 4 or section 36A of NDPS Act provides that if it is not possible to complete the investigation within the period of 180 days, then the custody of the accused alleged to have committed an offense under NDPS Act can be extended up to 1 year, subject to the two conditions. The first condition is that there has to be a report of the public prosecutor indicating the progress of the investigation. Secondly, specific reasons for detention of the accused beyond the period of 180 days has to be spelled out. Now, in this case, since both these conditions had been complied with, therefore, the order of the Sessions Court was upheld by the High Court. Now, moving on, this is a judgment that was passed by the Punjab and Haryana High Court in the case of Kamal Pal and another versus State of Punjab. The court has held that the judicial order to collect voice sample for investigation purposes does not violate right to privacy. So basically, in this case, what happened was the Sessions judge, it had passed an order allowing the Vigilance Bureau to take voice samples of the petitioner for the purposes of investigation. The petitioner, it filed a revision petition in the High Court contending that such collection of his voice sample for the purposes of investigation, first, it violated Article 20, subclause 3 of the Constitution, as well as it violated his right to privacy. The petitioner also contended that such magistrate is not empowered under Section 53 of CRPC to pass such an order to collect voice sample. Now, the High Court, it relied on the Supreme Court judgment of Ritesh Sinha versus State of UP, wherein the Supreme Court had held that the direction to take voice sample does not infringe upon Article 20, subclause 3 of the Constitution. The court further held that until explicit provisions are drafted in the Code of Criminal Procedure by the Parliament, or judicial magistrate must be conceded the power to order a person to give a sample of his voice for the purposes of investigation of a crime, and such power has to be conferred on a magistrate by a process of judicial interpretation and in exercise of the jurisdiction vested in this court under Article 142 of the Constitution. Therefore, the Punjab and Haryana High Court, it rejected the petition of the petitioner and it upheld the order of the Sessions Judge. Now, next judgment. This is a judgment that was recently passed by the Calcutta High Court. It's called Rampadha, Basak and another versus State of West Bengal. In this case, the Supreme Court, the Calcutta High Court held that the right of a senior citizen to reside in his own house and to direct eviction of his son and daughter-in-law if need be must be viewed from the prism of Article 21 of the Constitution. The court held that the children and their spouses living in a senior citizen's house, they are licensees at best, and such a license, it ceases to exist as soon as the senior citizen ceases to be comfortable with them. The judge further opined that a nation that cannot take care of its aged, old, and infirm citizens cannot be regarded as having achieved complete civilization. Now let's move on to the international developments that have taken place during this period. The Parliament of Sierra Leone, which is a West African country, it passed a bill to abolish death penalty. Then the UN Human Rights Committee, it found that the Mauritius ID card law, which contained the biometric information of the card holder, to be violative of the right to privacy of its citizens. Further, the European Court of Justice ruled that the employers, they can forbid their staff from wearing headscarves in order to present an image of neutrality in respect of religions. The Israeli Supreme Court, it ruled that surrogacy restrictions that have been passed with respect to same-sex couples that prevents them from becoming parents was unlawful. With this, I come to the end of this session. In case you have any doubts, please post them in the comment box and I shall try and clarify them. Thank you.